Hello, everybody, and welcome to the Church Liability Protection Series. My name is Jim Abbott. I am a partner at Litchfield Cavo, practicing out of its Chicago office. And I have been practicing for over 20 years, largely defending churches and nonprofit entities. Today, we are going to be talking about sexual molestation claims and lawsuits. And this is obviously a difficult topic, but a very, very important one. And together with my colleagues from the UCC Insurance Board, Cy McFarland and Monroe Moore, hopefully we are able to impart some wisdom upon you such that you know what to look for and hopefully prevent finding yourselves involved in such a claim. Cy and Monroe, perhaps you could introduce yourselves.
Sure, Jim. Hello, everyone. I'm Cy McFarland. I'm the Director of Claims Administration at the Insurance Board.
And I'm Monroe Moore, Senior Claims Examiner at the Insurance Board.
And Cy, before we get started, perhaps you could talk a little bit about what the Insurance Board does.
The Insurance Board provides an insurance program to 6 church denominations across the country. And those denominations are the United Church of Christ, the Disciples of Christ, the Alliance of Baptists, the Presbyterian Church USA, the Reformed Church in America, and the Evangelical Lutheran Church in America. And together, those 6 denominations comprise of more than 4,500 churches that we provide an insurance program for across the country. We specialize in general and professional liability coverages, property insurance as well, and also workers' compensation and commercial auto insurance.
Thanks, Cy. And having worked with these 2 gentlemen, I can attest that they're very experienced and very knowledgeable. And certainly following today's session, if you have any questions at all, I'm sure that they'd be more than happy to answer them. As I said before, today's topic, sexual misconduct liability claims, is a difficult one. It's a tricky one. This is something that I'm sure many of you have read about in the newspapers, and it's very, very important that any type of potential sexual misconduct situation be addressed properly. And Cy is going to kick things off by talking a little bit about some of the trends that he has seen on this particular topic, and then I will address the various legal considerations and counsel with respect to avoiding these types of claims and lawsuits. So with that said, Cy, can you take it away?
Sure. Thank you, Jim. All of us, anyone paying attention to anything in the media, the local news over the past 10 years, we've heard a lot about cases involving sexual misconduct, particularly with the Catholic Church, most recently the Boy Scouts of America. And unfortunately, these types of situations are on the rise. And they're not limited to those organizations. Protestant churches are also finding themselves embroiled in these types of situations. In fact, there was a recent article about a couple of years ago that said the sexual misconduct issues in the Protestant church are really the tip of the iceberg, and that is the one area that is going to increase as we move forward, and that is actually happening. So Protestant church leaders are not immune. Protestant churches are not immune from these situations. They all too frequently occur, and a lot of times they are occurring with a lot of church leaders not really being aware until it's too late and the situation has already taken place. If you look at the first graphic, for our churches that we have seen, the vast majority of these types of situations involve pastors and clergy members, where a pastor is accused of assaulting either a parishioner or another clergy member, and unfortunately, a lot of times, sometimes children as well. We see a lot of situations also, if you look at the graphic, involving youth leaders, because those individuals have a lot of interactions with children and youth. And unfortunately, those situations are becoming more common. We're also seeing a third situation involving child-on-child abuse. And that's something that is increasing across the country. It's very unfortunate, and it happens more often than churches will realize. So those are the three situations that we see, according to this graphic, that are comprised the majority claims that we see coming from our churches. If you look at the next graphic, we'll see that the claims involving pastors and clergy have been the most expensive. The one thing about sexual misconduct claims, they're extremely expensive. It's an extremely explosive issue. No one is really presumed to be innocent, unfortunately. The tide has changed a lot for clergy members, where churches were always presumed to have some innocence there, that nothing, the churches were viewed as a sanctuary, a place where children and teenagers are protected. Unfortunately, that is no longer becoming the case, and that pastors are looked upon now with a degree of suspicion, unfortunately. And the same holds true for teachers. We see a lot of situations with school systems as well, where they're no longer looked upon the same way they used to be looked upon maybe 20 years ago. We've seen that claims involving pastors and clergy have cost more than $1.7 million in reserves. Claims involving youth ministers. Those are individuals that lead worship, that lead youth groups. Those are equally expensive, costing more than $1.6 million. The average cost of these claims is in the six figures whenever it occurs. And the other thing we're seeing is that these claims don't always occur on the premises. They can occur, these situations can occur in camps. They can occur on retreats, individual homes as well. There's a long trail of, shall we say, red flags or signs that will occur once these claims are filed. And a lot of times these things begin outside of the church premises, but they always involve church business. They always involve an individual that is engaging in a church activity. A major pattern that we've seen is the grooming process, and that's the third thing that churches need to be aware of. These individuals, more often than not, groom their targets. And seemingly innocent activities, innocent gestures, but they're always physical. It could be a hug. It can progress from a hug to prolonged hugging. It can progress to wrestling, anything like that, where once these claims are filed, the one thing a plaintiff attorney will point out would be the red flags, and also a standard. The legal standard has changed. It's a legal standard that the church should have known or could have known about these situations. And they will list all of the red flags. And some of these things, in terms of the grooming process, took place over months, even years. A couple of years, if it's involving a young person coming into their preteen and then teenage years. So it's a very eye-opening situation, and an attorney puts out a graphic showing when this occurred, and they'll ask the church leadership, when did you should have known that these things were occurring, and did you do anything about it to prevent it? And we're seeing that it's very important for churches, therefore, to have very strong standards on policies involving anyone that interacts with children. Adult and children interaction should have very specific procedures, very specific policies that will not allow a one adult and one child or group of children to be together and alone in an area. It's very important. A lot of organizations now have specific policies that will make sure that there are, for example, at least two adults present. That there will be a thing involving any red flag, that ministers will report that to local authorities if there's anything involving a child where the child indicates that someone has touched them inappropriately, that they report those activities. And churches should have a policy in place that will specifically require that. Pastors, teachers, a lot of daycare leaders, teachers as well, they are called mandated reporters, and they are required by law to report any instance that could be suspicious involving a child where the child has indicated that he or she has been approached or touched inappropriately. We are finding that if churches ignore those situations, they can become very expensive lawsuits. And juries, unfortunately, do not look favorably upon children that have been assaulted in those situations, regardless if the clergy knew about it or not. It doesn't really matter in the minds of a jury when they hear about these egregious situations. So it's very important to have policies in place. It's very important to make sure those policies are renewed and reviewed every yearly, actually, but they should be regularly renewed and reviewed to make sure they're always kept up to date. The laws will change involving a legal standard for these types of claims. So it's important to make sure the churches are also up to date on how they deal with these situations. We're also situations, again, I mentioned, where we have more increasing situations involving child on child abuse. And it's very important also to make sure there's proper supervision. Whenever you have children congregating in an area, and there are specific standards on how many teachers, supervisors, adults should be present based on the adult-child ratio. We're finding that when that isn't adhered to, when churches don't follow those standards, then you have abusive situations involving children as well. So this is a very serious topic, and unfortunately, it's on the rise. And the legal landscape also has changed quite a bit over the years. And Jim will discuss a little bit more about what we're seeing, what he's seeing of the country from a legal perspective.
It does go without saying that these types of claims are very serious. What I would like to direct your attention to is how these claims are being brought, and specifically, what is the theory? And as you can see from this graphic, it may be a little bit different than what you had originally thought. The focus with respect to liability is not on the act itself or the acts. The acts may pertain to the nature and scope of the damages being claimed. However, the liability issue and focus on the church is its hiring, retention, and supervision practices. And so, in order to prove a sexual misconduct case against a church, the plaintiff must show that the employer, the church, knew or should have known that the employee had a particular unfitness for the position such that it created a danger of harm to minors. They also must show that the particular unfitness was known to the employer or should have been known to the employer either at the time of hire and or during the employee's employment at the church. Now let's break that down a little bit. First off, what is a particular unfitness for a position at a church? And whether we're talking about a youth minister, a pastor, associate pastor, even volunteers at the church, doesn't necessarily have to be an employee, but anybody who is an adult and is working at the church in some capacity, if they are particularly unfit for the position, they either should not be hired in the first place, or if that unfitness is discovered after the hire, they need to be let go. What is a particular unfitness? Well, simply put, it means that it's an individual who is not fit to work with and around children and adolescents. It's just that simple. If they are somebody that has a particular unfitness to be in that type of environment, the church needs to act on it immediately. Ideally, this is something that is going to be vetted during the hiring process. And we do see a number of negligent hiring claims being brought. However, the more typical claim is negligent retention and supervision. And the reason for that is that many of the sexual predators out there have clean records. They don't all have a criminal history. They are oftentimes very charismatic people, very outgoing people, people who make a very good first impression. And so frequently the issue with respect to their particular unfitness doesn't rear its ugly face until after they've been hired. That being said, the hiring practices are very important. There needs to be a complete and thorough background check on anybody who is seeking employment at a church. This is something that Cy and Monroe and myself could certainly assist you with, but there are a lot of different ways to go about vetting an individual. And frankly, this is something that at this point probably should require a fairly scant background check, including a search for any prior criminal history. The worst case scenario would be if the church hired somebody to be its pastor or youth minister or employee in any capacity, and they actually had a prior history of sexual abuse or sexual assault. That is a case that you really cannot defend for obvious reasons. A jury, as Cy pointed out, is already going to be disgusted by the allegations of abuse that took place at the church, but they're naturally going to wonder, why did the church hire this person in the first place? So a thorough and proper vetting and background check on anybody applying for a position needs to be conducted. With respect to the second part of the plaintiff's burden of proof, again, the first part being the particular unfitness of the individual, either a hire or during their employment at the church. The second part is actual or constructive notice to the church employer that this individual was particularly unfit for the position. Actual notice is quite simply when the church actually does know that the employee is unfit, if there is a history of any kind that suggests this individual should not be working with and around kids, that's actual notice. However, I can tell you that the trend that we see throughout the country is not actual notice cases, because in those situations, churches typically do the right thing. They know enough at this point not to keep somebody around who clearly has a sketchy history. So the should have known standard is typically what we see. And therein lies the problem, because there is a gray area there. And you're probably wondering then, well, if all they have to show is that we should have known about the employee's particular unfitness, what types of things do we need to watch out for? Cy touched on many of these already, but I'll go through some of them as well. There are frequently, particularly after somebody has been hired, there are rumors floating around. This typically occurs following a retreat, a camp, something that takes place outside of the church property at somebody's home, a youth ministry trip, for instance. Kids talk and parents then hear things. And so even though rumors and gossip is not something that is necessarily accurate, it is something that has to be looked into, because that may be your first flag or warning that this is something that we have to investigate. We're hearing some things, and this is disturbing what we're hearing. Anybody who makes a complaint of any kind, even if it seems relatively innocuous, about the employee, that might suggest, is this person someone that we think can work with and around children? That's something that has to be looked at as well. Observations are very important. Is this employee revealing public displays of affection towards a particular child or adolescent? That is clearly a red flag and should be addressed. In today's day and age, that is really something that should never happen. Even hugs have to be very, very, carefully looked at under the circumstances. A hug, at a funeral, for instance, is very different than something that's more casual. So the context is very important. That being said, generally speaking, there should not be any touching at all, or invasion of an individual's personal space. We live in an age of technology, and social media is something that needs to be monitored. We don't want to invade the privacy of employees. However, there are things that when they are on church property and they are using a computer, there are things that they clearly should not be allowed to do. But we do see a lot of cases, unfortunately, where after the fact, it's discovered that the church employee was posting things on social media that raise red flags with respect to a particular child or adolescent. We know from the confiscation of cell phones that there are inappropriate text messages that are being sent, oftentimes inappropriate photographs that are being sent. We frequently will see situations where the employee, upon being arrested, they will have their personal computer confiscated, as well as the computer they used at the church confiscated, along with their phone. And the investigating officers and state's attorneys are going to look at all of it. And again, a lot of information comes out through all of that technology and social media. Grooming is something that is very, very real. In fact, to echo Sai's point, I don't think that I have had a case where grooming was not alleged. Grooming is something that uh, predators almost always do. They will start out small, they will start out slow um, in order to gain the trust of their target. And that may be initially by giving them a gift. Um, it might be doing something nice for them that on the surface doesn't seem like a big deal, but peel the onion back a little bit and you have to question, why is it that they are doing this for one kid and one kid only? So that's typically a red flag. They will oftentimes target the most vulnerable children. These individuals, these predators, are smart. They know that more vulnerable kids are more likely uh, to earn that trust of the groomer, and uh, they will build a relationship in that regard. And that is oftentimes a product of a broken home. Perhaps there's a minor who only has one parent at home and that parent works a lot. And so they're actually in a situation where they're entrusting their child to be more involved, perhaps with something like youth ministry. And unfortunately, these groomers, they know what they're doing, and they know that a more vulnerable kid who doesn't have uh, the same steady home life that another kid has, they're more likely to be targeted. And they're more likely to not say anything once the grooming process begins. The groomers will say things like, upon giving them a gift that's clearly not something that should be given. Oftentimes it's something rather expensive. And they will tell the child or adolescent, don't tell anybody, it's just our little secret. Um, these are the different ways that uh, predators start the process. The grooming process then typically escalates once the trust of the child is earned. It then will escalate into something physical. Always with the caveat, don't tell anybody. And so we have to be very, very observant, and any possible um, way that we can vet existing employees. It's one thing to vet them when they're in the hiring process, but oftentimes once hired, um, employers tend to stop vetting, and that really can't be the case anymore. We can never stop vetting. And so seeing an adult volunteer or church employee who's in an employer capacity, one-on-one, behind closed doors with a child or adolescent, that's a big no-no. Every church should have a safe church policy in place that dictates that there should never be one-on-one situations like that. If we're talking about youth ministry, and that's something that we see often, because so oftentimes the victim is very involved with the youth ministry. Um, there should never be a reason for there to be one-on-one interaction. They're in a group to begin with, and so if it is learned that there has been one-on-one interaction, even if it just appears to be talking without knowing exactly what the two parties are discussing, that's something that has to be questioned. And there needs to be a sit down with the adult as well as the child into what was the circumstances. It's better to be careful and make perhaps an overly aggressive mistake. It's certainly not an accusation, but at least asking about what's going on. Did you give this gift to that child? Did you give that child a ride in your car with nobody else? Were you talking to that child in your office with nobody else around? Things like that have to be questioned. Cy touched on the safe church policy. That's clearly very important. Every church must have a safe church policy that specifically addresses these issues. But it's equally important to enforce the safe church policy. We can't just give lip service to it. It's not enough to have the policy and then hide behind the policy if ultimately somebody with the church is accused of being a predator and having sexually assaulted a child. It's not a defense to say, oh, but we had a safe church policy if it wasn't being enforced. So it has to be enforced. It has to have some teeth to it. There should be some type of training for every new hire and volunteer with respect to church safety. And there should be a written statement that the new hire has to sign indicating that they were trained on the safe church policy. These are things that need to be done at the outset of the employment. Take any and all complaints seriously. That includes the rumors and gossip that we talked about before. If it's coming up again and again, then that's not something that, while technically at that point gossip or rumor, that's not something that we can blow off. We have to look into the why a certain rumor is going around. And oftentimes, if a complaint or comment or observation is made, it's not from the parents. It's from another child, particularly in the youth group or youth ministry type setting. Oftentimes, the biggest tip-off is that a close friend of the victim will come forward and say something because, this isn't right. And parents are, let's be honest, they're very busy and they don't necessarily even think to go to the church and bring something like this up. It does happen. Some parents do, but so often it is another child if somebody is in fact bringing information to light, and that can't be swept under the rug. It has to be taken seriously. These types of cases, the crime of the individual is certainly a criminal matter, but we're talking about civil lawsuits against the church. And so again, we're talking about negligent hiring, negligent retention, and negligent supervision. And so the conduct that is going to be looked at by the court, and if it goes to trial, a jury, is the hiring practices and the supervision practices of the church itself. Was the church employing a sound and comprehensive safe church policy, and were they actually enforcing it? And if there were any red flags, did they act immediately upon them, or did it just basically get ignored or swept under the rug? I can tell you from experience, jurors are even more angry at an employer who sweeps this ugliness under the rug than they are with the initial act of the perpetrator to begin with. The sweeping under the rug is something that will potentially lead to punitive damages, and that is a situation that nobody wants to be in. So we have to create good policy. We need to train our employees and volunteers on safe church policy and procedure. We need to get them to understand what potential red flags are, and we need to encourage people to speak up if they see such red flag. We oftentimes have to deal with the media once a lawsuit is filed. And once a lawsuit is filed and somebody like myself is brought in to defend it, frequently a lot of the damage is already done. And so what we want to do is get out ahead of the situation. If, in fact, upon doing some investigating, once there is a red flag and there's legitimate concern that somebody with the church may have sexually molested a child, it's a good idea at that time to get the UCC board and myself involved because we can walk you through the steps that should be taken. And that's very important because oftentimes these matters are brought to the church's attention first as a claim well before a lawsuit is brought. And there is a statute of limitations in most states for these types of cases that is very, very lengthy. And so a minor who is sexually abused does not need to bring their lawsuit within 2 years of that abuse. Frequently, it doesn't have to be brought until long after they become an adult and they've reached the age of majority. And in some extreme instances, we end up defending cases where the now adult plaintiff claims that they had repressed their memory of the abuse. And so sometimes we are in a situation where we're facing this lawsuit, having to defend it, and the alleged acts of abuse occurred many, many years earlier. And it's still within the statute period for bringing the lawsuit. So again, the more we can do at the earliest possible time, even if it is unknown at that point whether it's going to lead to a lawsuit or not, that is critical in addressing the situation. With respect to these types of cases, again, the difficult aspect of them is that plaintiffs don't have to show actual knowledge of the abuse. But if they should have known something was going on, if there are these little mini red flags and nothing is done, then plaintiff is going to be able to prove their case for negligent hiring or negligent supervision. And so, again, just to kind of reiterate, the giving of gifts, the doing of things that on the surface appear to be very, very nice, but involve just one individual rather than in a group setting. Those things need to be questioned. Rumors and gossip that may be floating around. You need to get to the bottom of it. If for no other reason, then you don't want rumors and gossip floating around the church. And so, again, understanding the grooming process, understanding how that works and how that typically escalates into something very, very serious and illegal is extremely important. Those are the comments that I have from a legal perspective. Certainly welcome Cy and Monroe to add anything additional to that.
You said a lot of things that I was thinking of, a lot of things I'm seeing. It's amazing when you find churches that are not aware, and these are good people. I have to emphasize that most of our churches, in fact, 99.99% of the leadership, the clergy, these are very good people. They're caring people, and they're recognized by these situations almost as much as the victim that was of the assault, because a lot of times they're unaware that this was even gone in their congregation or in their youth group. And it's an unfortunate surprise when it does occur. I do want to emphasize it's very important. I think Jim pointed out, if you find out that this has occurred, you must report it to the authorities. pastors, church leaders, there are mandated reporters, and so they must report this situation to the authorities, and that there is no real leeway on that. They have to report these situations. Also, Jim mentioned about rumors, or we spoke about that earlier. They can't be ignored, especially in these situations. Unfortunately, we find in the cases that we have received that the rumors were true. When they start out in this type of context, they have to be taken seriously, therefore. And also the training. Jim had mentioned that. I mentioned it earlier. Can't emphasize enough the need for training for leadership, for church leaders. There are a variety of resources out there. We at the Insurance Board have resources available that provide this type of training, where the training will point out what these red flags are. They will point out specifically the grooming process, so how you can understand how these sexual predators think and how they target certain individuals. The training provides a lot of very important information about that. Also, the safe church policy, Jim mentioned as well, not only to have, but to also enforce it. And also to up yearly if necessary, and to make sure that your staffs are well acquainted with the policy and that it's followed. It's not enough just to have it, but they must also follow those policies. Can you prevent? These are all preventative measures also. So can you prevent these type of things from happening? We should. We really do. Unfortunately, that these are things that, in some certain situations, they may not be prevented because they can go on without, a particular person being aware. However, they can really be mitigated. A lot of times, if these predators will see that a church has an effective safe church policy, there's effective training, they won't pick that church to work in. They'll pick a different place. A lot of them specifically look for places where those policies aren't there. So this is a good way to make sure that you lessen these types of opportunities, that you lessen the impact or the chances that these things would occur.
Thanks, Cy. And Cy is correct. The vast majority of the volunteers and people who work at our churches are very good and decent people. Unfortunately, in these lawsuits, that in and of itself doesn't defend against the allegations of negligent hiring or negligent retention or negligent supervision. If red flags are missed, very good and decent people will get dragged into this type of litigation. And so the key really is training, having effective policy, and getting people to understand that, hey, we are a church that is very aware of how grooming takes place. We know it when we see it, and we will act on it. We will do something about it. We will alert the authorities. And we don't want people who are using our church as a vessel to take advantage of the more vulnerable children and adolescents who are members of the church. It's a heavy topic. It's important. And we are here if you have any questions. On behalf of myself and Cy and Monroe, we want to thank you for your time.